rules of civil procedure can a school attorney and an independent hearing officer implement? Mississippi State Board policy adopted only Part B regulations for due process hearings. State law adopted the same, but our hearing officers keep implementing rules allowed for other civil proceedings, and I'm assuming you mean the federal. Limiting the scope of the complaint after finding all allegations are sufficient. And I'll address that because it sort of depends. Limiting the number of witnesses, and that also sort of depends. Implementing Rule 68. My pro se parent has no idea what this means, and I'll explain that as well. Ordering the parties to hold an IEP meeting after the resolution period has passed and no resolution was reached. What recourse do parents have to put a stop to these overreaching practices? Okay, so we loosely follow the federal rules of civil procedure, okay, and I'm talking about in all the states that I have an office in, okay, loosely follow those. Why? Because this is an administrative branch off of the federal court, so we don't use state court rules. The states have adopted the federal IDEA regulations, but as far as embedded practices, as far as rules, they have some, but at the same time they don't sort of have the formality, timelines, requirements, things of that nature. We don't want any. There needs to be some flexibility there, and believe me, they're applied quite freely in most of the cases that we have that have gone to hearing, meaning that yes, there's a 5 business day exchange deadline for witnesses and evidence, okay, documentation. But at the same time, I don't think I've ever been in a hearing where the school hasn't, or even us, where they haven't introduced additional documentation later and had it been admitted, okay, past that deadline. Now, you sit there and you go, oh, I object. Well, yeah, you can object and they'll note it. But part of the reason that the hearing officers are far more flexible at this juncture in the process is that by objecting or by sustaining that, or let's say by prohibiting that those additional documents, or by limiting witnesses or things of that nature, and I know that was one of your questions. What the hearing officer is doing is they're basically giving the school, or they're giving the parent the gift of potential justifications for appeal, meaning your decision was wrong in part because you limited or you did not allow in this very relevant documentation that we found or identified at a later juncture that was relevant to this hearing process. Because hearing officers are triers of fact, meaning that they're also fact gatherers, because the only reason that we have this administrative process of due process on this level is so that we don't overwhelm the federal courts with these cases, okay? They're not state court cases, they're federal cases. And we don't want to sit there and overload our federal courts with a bunch of due process hearings. That's why we created this administrative hearing, and we have independent hearing officers. They're not real judges though, okay? They're attorneys that have been trained in this law, but they're not judges in the traditional sense. They have limited power and authority. And that limited power and authority is spelled out very clearly in the IDEA. They cannot go beyond that. I mean, even on the issuing of subpoenas, they're not real. They're sort of real, but they're not real, meaning that I ask for record production all the time. And it works most of the time, because most people, when they see, a subpoena, they go, oh crap, I need to provide this stuff. But in reality, there's no there's no enforcement mechanism because the hearing officer doesn't have any power to compel or enforce the subpoenas they issue. So seriously, on many levels, this is sort of an honor system and I say this, I'm saying the true part out loud, guys. That this is an honor system. That there's a few school systems, there's a few board attorneys that are a real big pain in my ass because they told me, you know, that those aren't real judges. I don't have to listen to them. I don't have to do what they say. And they're just an impediment and the pain in the ass in this entire process because, you know, they know that this is a sort of a farce, meaning it's not a real court. It's an administrative hearing to where the hearing officer collects the record, takes the testimony, and renders a decision based upon observation, what he or she hears with regards to testimony and what's contained in the record. And they are equipped to make that determination. But still, you have a right to appeal that to a federal court, and then that federal court with a federal judge does what's called a de novo review, meaning that one aspect of it is an appeal, but then the other aspect of the case is a brand new case because a hearing officer can't rule on law. They can rule on the facts based upon that testimony. And like I said, the observation of people's body language and the inflection in their tone and, a general sort of take on whether or not they were a believable witness. And then also the record. And so, yeah, if it goes to appeal, the federal judge gives it a lot of deference with regards to the perspective of the hearing officer, but at the same time, they don't have to, they can do their own thing as a federal judge, and especially if there's a novel issue that's an issue of law that the hearing officer can't rule on, then that would be part of the de novo part. So with that being said, guys, some of these things done on a hearing officer level could be appealable and give cause or good reason why the parent or why the school would appeal and then potentially have the hearing officer's decision overturned or thrown out for some technicality. And so it's just easier for them not to sit there and get too stuck in the rules and get too rigid as to take away the little complaining things. Well, he didn't let this stuff in, after this time. And I think it's parents that tend to be more rigid in their thinking, believing that this is, some high and mighty court process, and it's not. It's very complicated. It's very complex. And quite frankly, I think it's the hardest area of law to argue in. Why? Because I don't get the benefit of deposing people. I don't get it. I don't get depositions, to where I know what these people are going to say in advance of having them on the stand because I've had the benefit of deposing them and asking them these questions. And if they lie on the stand, I have the benefit of this record saying, well, during our depositions, you said this. Oh, no, not in this process. See, James has to sit there and think on my feet. I have to be good. I have to be spot on. I don't have a clue what's coming out of their mouth when I'm questioning a school employee or an administrator. No idea. And that takes a skill set that's far beyond even a regular litigator, because you have to sit there and be able to take what they say to you in real time and be able to sit there and know what to say next, where to go next. You don't have the benefit of knowing what's coming out of their mouth. That's a scary proposition as an attorney. And so this is not an area for the faint of heart, and it's not an area for bad attorneys because they'll get their clock cleaned. Why? Because on the parent side, we're the ones with the burden, except in a few states. So we're the ones that have to prove our case. The school gets to play defense, and that's an easier thing to play. Um, Rule 68. Rule 68 is in the law. I don't know why they would be referring to civil rules of the federal rules of civil procedure. I mean, it's in the IDEA, meaning that there's something in the IDEA in the due process segment that's called a 10-day offer. And if they make a 10-day offer prior to the hearing, and it is fairly close to what it is that you're requesting, and you turn it down and proceed to hearing, and you don't achieve that level or greater, then it's not good for you. Okay, and especially if you have a parent attorney and you reject a good 10-day offer, then there's a punishment mechanism built in to where your attorney is responsible for the school's attorney fees, potentially, for rejecting a good 10-day offer. So, because what they look at it as basically retaliation in reverse. That the parent is unnecessarily protracting the case because they have an axe to grind, not because they want corrective action for the child. And remember, that's the focus of these cases. It's not retribution. It's not a payback system. This is about corrective action, and that's what the court built in as a mechanism to keep parents from unnecessarily protracting these cases past the point of reasonableness. Now, on the flip side, schools will protract these things and drag them out, and I can tell you on the back end, if you have a parent attorney involved, one of the punishment mechanisms for the school for doing the same thing is that they cannot discount or reduce the attorney fees that you're requesting be paid by the school. That's their punishment. Because in all of these cases, guys, that we've won, we have to go into federal court. We have to sit there and present our bill. We have to sit there and justify why it was so high, and they are high. These are not easy cases. So due process is expensive. But in a lot of these cases, the judges will line item it and go, well, nope. And then what ends up happening is, we usually get knocked down a percentage in that process to recover the fees. But on the retaliation side, for unnecessarily protracting, they would lose that ability, which then costs the school additional money. So there are some equal balances there. So that 10-day offer is there to try to reduce the cost of a hearing. They may call it a Rule 68, but that's all it is. It's just a 10-day offer. And that's going to be within the Mississippi Code, just like it is every other state in the nation. As far as ordering an IEP meeting, that's not uncommon. Hearing officers can also order the schools to pay for independent education evaluations. They can order these things. Why? Because during the mechanism, if there's some need for clarity, then the hearing officer can do those kind of things. So that's not necessarily uncommon either. Like I said, as far as limiting witnesses, I think everything, and I've had a few sort of question, this laundry list and it's usually the schools that do that, because my list, I want to have a focused witness list. There's something called overkill, guys, and that's very, very real. And you don't want overkill in this situation. You want a very, very clear, unconfusing pathway. And it's typically the school that will provide a witness list of 30 people. And that's when the hearing officer's like, come on, what's that about? You don't need that many people. And logically, you don't need that many people. Unless there's very valid reason. But that's also why you submit your witness list. You sort of need to put out next to it what they're going to be testifying to. And if you have multiple people on that list testifying to the same thing, then it goes back to why a hearing officer would say, I get it. I get this, here. So therefore, do you need to sit there and break down? Because understand there also needs to be that balancing and respect of public monies that are used. And I'm not, special education funding can't be used for these kind of things, but I'm just saying we need to be cognizant of public monies and also not to convolute or confuse. And that is a strategy of the school. The strategy of the school is to sit there and convolute and present too much and swamp them with documentation that doesn't make any sense. Swamp the parents as far as in the exchange with 1,500 documents, and I can tell you 500 of the 1,500 are just the same documents, and they intentionally insert it in there, and some things are out of order. It's all done as a strategy to send you into paralysis analysis way out there to where you can't focus and streamline the argument. And so your witness list shouldn't be that high. You need to just be very, very mindful of who you need on in order to show definitively that your child was denied a FAPE due to whatever the parameters within the IDEA allow: location, evaluation or eligibility, academic, the lack of progress. I'm not going to go into that. I mean, I've already been doing this for too long, but I hope that makes sense. Okay.